Well, it's time now to answer some of those legal questions you've been sending in, and we turn to Fox 26 Senior Legal Analyst Chris Tritico. Good morning, Chris.
Good morning, Jose.
Okay, we're starting with a question from Nay, who writes, my apartment unit and entire complex is infested with rats, mold, and roaches. Nobody will do anything about it. What do I do?
Well, you have a right to live in a rat-free apartment, and so what I want you to do is document this with photograph and video evidence as best you can, and then write them what's called a 10-day letter. Under the Texas Property Code, you can demand that they remedy this problem within 10 days. This is a habitability issue, so document that they're in your apartment and send them a 10-day demand letter that they remedy the problem. If they don't fix it in 10 days, you have the right to move out. Now listen, this doesn't mean you don't get sued for breaking your lease, but it gives you a good defense to that lawsuit. Good luck.
The next question comes from Reginald, who writes, is there a group that oversees companies that do not participate in the Texas Workers' Compensation Program? I was told there is no requirement for companies to take part, and that Texas Workers' Comp has no control over non-subscribers or non-members. I hope you can help.
Well, I can give you an answer. I don't know if it's going to help much, but whoever told you that was absolutely correct. Workers' compensation is insurance, and there is no Texas law requiring that a company have workers' compensation insurance. But what the law also says is if a company chooses not to have workers' compensation insurance, they also don't have the protection of a lawsuit protection. If you have workers' compensation insurance and a worker gets injured on the job, the employer cannot get sued for that on-the-job injury. If you don't have insurance, workers' compensation insurance, then your employee can sue you if they get injured on the job. So that's the trade-off. So nobody controls this. There's no oversight, but if you go without insurance, you're subject to getting sued. Good luck.
Our next question comes from Jennifer, who writes, my daughter has been living at the same apartment complex for a year and a half. When she signed the lease, there was no mention of a pet deposit. We were told all pets are welcome. So last January, she got a dog. The complex knew and didn't say anything about it until now. She received a letter complaining she is in violation of her lease and is being charged a $100 fine, a $300 pet deposit, plus a $250 charge, which I don't know the reason for. There's also a $25 monthly pet rent fee. Can they make these charges when it wasn't in the lease?
No, if you have a valid lease that says there's no pet deposit and no pet fee required, then until the end of that current lease, they can't just unilaterally modify it and start charging you for that. Take a copy of the lease and go down and meet with them and show them that lease. What they're going to say is, well, the rules changed. Well, that's not your problem. That's theirs. And they'll have to wait until the lease changes, until the lease is up. And at renewal, they will then add that to it. But they can't charge you today. Good luck.
Thanks a lot, Chris. As always, great responses. Now, if you would like to send your legal questions, just go to our website, fox26houston.com. You can find Chris's segments under the Morning News tab. And as always, for any specific information and advice, you should contact an attorney of your choice.